Welcome to this session. This session looks at the LPM Framework, which was developed by the International Institute of Legal Project Management. My name is Todd Hutchison. Well, firstly, it's very important to notice that legal matters are projects, and people leading legal matters are therefore legal project managers. So lawyers have always been legal project managers, we just haven't referred to them in that regard before. Now, it's important to recognise that historically the billable hour required minimal planning, and therefore didn't have to look at some of the traditional things like risk management, issues management, etc. And because of the change to alternate fee arrangements and things like fixed price services, lawyers are actually having to more apply the principles of traditional project management to legal matters. But when you look at it, legal project management is the application of project management principles and practices to enhance the delivery of legal services. But interestingly, the Institute reviewed and surveyed practitioners in over 9 countries. And they found that legal project management as a phrase, as a term, actually covers far wider than just project management principles. For example, it found that technology enhancement, which included artificial intelligence and practice software, as well as process improvement, which looked at legal design and the development of workflow processes, and as well as people leadership, which looked at the interpersonal, the communications, the interactions and engagements of people. All these require far more focus when legal matters are of a complex nature. Now, if you go back and look at the traditional project management, the Project Management Institute, the largest professional association in the world for the profession, developed a project management de facto standard called PMBOK. PMBOK actually stands for a Guide to the Project Management Body of Knowledge, and its current edition is the 6th edition. PMBOK recognises that there's actually 10 knowledge areas, or otherwise known as functions, of project management. These include scope management, cost management, schedule management, quality management, risk management, human resource management, which they tend to recall resource management, communications management, stakeholder management, procurement management, and integration management. Of course, integration management is the hardest one to understand because it goes about explaining how they all interact. In fact, if you change any of the other 9 knowledge areas, you're actually impacting at least 2. So therefore, if I was set on my schedule, but I was falling behind on my work, I might be able to bring in more human resources. But of course, bringing more human resources would increase also the cost. Given these 10, it was very important to work out what was more relevant to legal matters in a legal context. So what is the difference? Well, in legal matters, we don't call them legal projects, we actually call them legal matters. And of course, the legal context is quite different because there's multiple parties involved and there's legal advice or maybe court action that is occurring in the types of projects that legal matters deal with. Therefore, legal matters is largely around professional advice type projects. And of course, there's a lot of regulatory obligations, things that are fixed in the way that it's approached, particularly in the courts. Now, costing models can be quite unique to some of the law professions because the alternate fee arrangements are being developed within a legal environment for a legal environment. And of course, not all of those 10 areas are as relevant to legal matters than they are in other projects, such as procurement management, which is very much about asset management and supply. And lastly, the legal profession has its own technology that includes artificial intelligence and practice management software. The Institute created a 4-phase LPM framework to help lawyers understand more the application of projects to legal matters. This includes looking at the context, the tools, and even the people skills, but breaks down a legal matter to recognise that it actually operates within a 4-phase life cycle. That is, define, plan, deliver, and close. Let's have a look at each of these items. Firstly, their external factors. This really sets the context. Clearly, different countries have different laws and different regulations, and even the actual principle of law can be quite different. The legal market that you're operating in, which includes the different competitors, and that can have an impact on the prices being offered and even the way legal matters are actually managed, such as between alternate fee arrangements, from a billable hour to the fixed price. And of course, regulatory obligations between both the country but also the organisation, the type of legal matter that's impacted. And lastly, the commercial factors between the legal practice and that of their clients. So this sets up the external factors before we even start looking at the legal matter. Now the first phase, the define phase, is really where we understand the full context to the legal matter and the full scope. This includes which parties are involved, the actual type of legal matter itself, how we go about collecting information, what information is available, defining what work is required, which we call the scope definition, but also what's the purpose behind this engagement, what's the objectives for the client seeking our help. And of course the assumptions that go with what we believe to be truth or facts to the matter, and the constraints, those boundaries or restrictions that's going to impact the type of work we do and how we even plan and execute it. Now in the plan phase, this is where we get down to get the exact schedule, resources, cost, and even pricing for the legal matter. Of course, by defining each of the tasks, that allows us, with the dependencies, to determine the actual schedule. From having that schedule, we would be able to look at what's the human resources required, as well as any equipment, consumables, or other things we may need. We'll be able to then determine the actual cost to the legal service, and of course, the pricing that will be given to the client, which would typically include a margin or markup. We have to look at things like quality metrics, how we're going to deal with stakeholders and who and which stakeholders exist, how we're going to communicate with them, and of course things like risk strategies, which looks at anything that can slow down, stop, or hurt the legal matter that would require a treatment strategy. Now when we go into the deliver phase, this is the execution of the legal matter, where we actually start the work and we start progressing all the tasks required to complete the work and deliver the deliverables. Now those deliverables could be anything from legal instruments through to court decisions. This is where the leadership skills really come in effect when we're trying to guide the work and utilize multiple parties to get things done. This requires the monitoring and controlling of work, but also the communications and the reporting within the team and between the team and outside key stakeholders, particularly the client. We have to look at risks and put in risk treatments to actually make sure those risks don't become an issue. And where they do become realized and they have a negative effect, we then have to be dealing with issues management. But issues management can relate to anything that's slowing down, stop, or hurting us at the time. And of course, even with fixed price legal services, there can be changes. And where changes are proposed, we require variations management. This allows all the tasks to be progressed to the correct level of quality within the time frame and costs required. And the closeout phase is where we finalise, discharge and reflect on our lessons. We actually hand over any legal instruments or the decisions made by the court. We ideally get client sign-off to confirm the legal matter has come to an end. We actually pull the team together and look at what worked and what didn't. And we have a review, which is called the lessons learnt, of which things we would recommend for future legal matters. And of course, that could include advice to management on how we might be able to better do, plan or execute legal matters in the future. We often have to discharge all payments due or owing. We have to archive the information, and in the event of having evidence, to make sure that is accurately kept. And of course, this is where the team disband. In the team disbandment, we typically are reassigning them to other legal matters, or effectively giving back to the law practice to then reassign. At that point in time, we've actually closed the legal matter. In addition to that, we've got to look at the productivity tools and the enabling approaches, such as legal design, how we actually set the workflow and how we design the systems around human-centered design, which basically means for the use of people, for the delivery to people. That includes the workflow design of our practice management software and all our systems, processes and templates. Of course, all the templates, checklists are the tools themselves and how we interact and set up technology, which is now starting to look at things like artificial intelligence and how we can integrate with that technology. Of course, the team dynamics is very important because legal matters can bring up a lot of emotion for people. And of course, legal matters can cause stress, and legal profession is found to be one of the most stressful environments to work in. This means that refining our leadership skills, refining our interaction and interpersonal skills between the team and outside with key stakeholders, how we actually set up a positive environment which constitutes our legal service culture, and of course how we take those knowledge and skills and competencies and develop ourselves to improve the capability of the organisation. So that is the 4-phase LPM framework. And when you look at it, what we haven't shown here is the many tools and techniques that the Institute provide in managing each of those components. Now, when looking at those templates, just recognise that templates can inform the design of workflow and must be modified to suit the legal practice. This can include considerations how it changes to meet the financial and other systems that are being used in the legal practice. This framework was designed to give people more of an idea of what LPM is and what it comprises of.